Assalamualaikum warahmatullahi wabarakatuh. So today we are going to discuss the topic pure economic loss. The slide belongs to Dr. Soni and I have done some minor editing to the slide. Let's have a look at the topic. Okay, for this is just a small topic actually, but we are going to focus on the important principles of law, okay, for the topic pure economic loss. So there are three parts of our lecture. So first we are going to discuss on the definition, the meaning of the word. And then another two parts, the following parts will be, the first part is will be covering circumstances in which what are the situations in which pure economic loss are not recoverable. And later, okay, after we are done with the second part, then the third part will be what are the situations in which pure economic loss is recoverable. So meaning that here it is divided into two possibilities or two possible circumstances. First, not recoverable, and then recoverable. Let's go to the definition. Okay, when we talk about economic loss, okay, in relation to TOTS, okay, TOTS law, so we have three different, similar but different, okay, different definition or interpretation of the word. Okay, what is economic loss? Okay, so basically when we see the word economic loss, it refers to pecuniary or financial loss. But the term is broad, okay, because economic loss will cover consequential and pure. So if we were to draw mind mapping, okay, or diagram, so we have the word economic loss, and then it is divided or classified into consequential and pure. So what is consequential economic loss? So consequential economic loss losses are losses which are incurred, okay, as a result of physical injuries or damage to property. So it's consequence to that, okay, meaning that here first, the claimant or the plaintiff suffered from physical injuries or even damage to property, and whatever losses flowing from these injuries, okay, it is considered as consequential, and most of the time it is allowed to be claimed. And another term, which is our topic here, is pure economic loss. So what is pure economic loss? So it refers to other losses that follow, but which do not flow from the damage, or in a way, okay, actually it is independent from it. If you look further from the case law later, actually there could be some indirect linkage, but then overall as a whole, actually the court or the law will consider as it is independent from it, not really directly connected or related. So the word is independent from it, or do not directly flow from the damage or injuries. So that's basically the definition. So there are three interpretation of the word here. Economic loss, we have consequential economic loss, and we have pure economic loss. All right, so this is the leading case which discuss about pure economic loss. The case is Spartan Steel and Alloys Limited and Martin and Company Contractors Limited, reported in 1973 in Queen's Bench. So here we have complainant and defendant. So C refers to complainant. So complainant had a stainless steel factory, so he's the owner. And then the factory obtained electricity, the supply of electricity by a direct cable. So they were using cable like in the picture from the nearby power station. And who was the defendant? Defendant were doing work on the ground, okay, with an excavator. So they use all the heavy machines, excavator, and in the course of doing their work, they negligently damaged that cable, okay, in which the electricity is supplied to defendant's factory. So what happened next? As a consequence, the factory belonging to the claimant was deprived of electricity. So it caused blackout, right, basically, okay? For how long? For 15 hours, so it's quite long. And because of this deprivation of electricity here, no electricity, cannot do work. So it caused three losses here. Okay, the first one, physical damage to the factory's furnaces and metal. It damaged the equipment, okay? And the second loss, lost profit on the damaged metal, because now the metal is damaged, then they suffer from lost profit. And the third one, they are also suffering from lost profit on the metal that was not melted. I mean, they cannot proceed with the melting. Okay, with the melting work here. During the time, the electricity was off. So they also suffer losses in respect of that. So the complainants, Spartan Steel, they claim all the three hits, all the three categories of damage. Okay, as I mentioned earlier, 1, 2, 3. Okay, and when the case was decided, okay, brought to the court, so this is the decision or observation by the court here. The first two claims, okay, I put that, I reproduce again, what are the claims? Okay, the first two claims, first and second, they were allowed, okay, because they were, okay, these losses were consequent upon a threat of physical damage to the plaintiff property. So the first claim and second claim, the second loss and the first and second losses together, they are considered as consequential, directly related to the no electricity, okay, because of the damage caused negligent act by the defendant. But as far as the third claim was concerned, okay, the third claim was not allowed being a pure economic loss. Okay, what's the third claim? Lost profit, basically a loss on paper lah, calculated. Okay, lost profit on the metal that was not melted because they are supposed to melt certain metal, but they cannot do it. Okay, so the court held that this is something which is pure economic loss. And then it was also observed that complainant suffered these losses, the third one, okay, because he was prevented from using the furnace. And meaning that here there are some other reason why he cannot use the metal here, because he can, I mean, complainant cannot use the furnace. And actually it's not directly, okay, it's not consequent upon physical damage to the property. So the furnace was not damaged actually. Okay, they can do the process later. All right. So the third one, okay, is considered as, I mean, it fell under pure economic loss and cannot claim for the third hit or the third kinds, okay, of losses here. The first two were allowed. Okay, that's the example of consequential economic loss. But the third one, this is an example of pure economic loss. So meaning that in a way, it is independent from the actual damage. Okay, there's no damage whatsoever to the metal. Okay, let's have a look at our own local case. When we discuss negligence, we actually discuss many cases, okay, which were filed in respect of the Highland Towers, the collapse of Highland Tower, the tragedy, and this is one of the cases which was filed. Okay, MPAJ, Majlis Perbandaran Ampang Jaya, and Stephen Kua Cheng Lun, and this one is reported in year 2006, and we want to focus on the judgment or observation by the former Chief Justice, Steve Schiff. What did he say? He said that one of the grounds of allegation or claims, argument by the parties. So the third question postulated the consideration of, so it relates to this, whether pure economic loss is recoverable or not under Malaysian law, under Malaysian jurisprudence in negligence and nuisance. And then the court went on to say expressly, in the law of negligence, there is no immutable rule. What is the meaning of the word immutable? Unchanging or unalterable. Here, most of the time, law is meant to be dynamic. It is, I mean, it changed from one time to another, depending on the situation, depending on the depending on the environment, depending on the society. So there is no immutable rule, that pure economic loss is not recoverable. So mean that here, sometimes we should allow the claim for pure economic loss. It's not mean that here, it's not irrecoverable for all the situations. Sometimes it should be allowed to be recovered. And then the court also said all major Commonwealth jurisdictions, including Malaysia, recognize that pure economic loss is recoverable in negligence, provided it meets the requirement. And then the court also make it clear, the court referred to English law, common law. So the court said the general duty of care test, enunciated, established in Caparo, we discussed thoroughly Caparo, applicable to all negligent claims, actually including claims for pure economic loss. So if you apply the test of Caparo, remember the tripartite test, so it doesn't prevent pure economic loss from being recoverable if all the elements in Caparo are fulfilled. So the party shouldn't be prevented from claiming for pure economic loss. That's what the former CJ explained or decided. And then this is appeal case. So respondents submitted, this is the argument actually, okay? 3 reasons for their argument. Respondents submitted that they should be allowed to recover economic loss against MPAJ, meaning dia Stephen Hua Cheng Loan claiming against MPAJ. So one of the losses suffered actually was pure economic loss. And respondent was trying to convince the court, please allow us to recover. And this is the reason. Okay, there are 3 reasons actually, okay, in the case. The first reason, the danger posed by the concept of diverting the stream across the hill slope behind Highland Towers was reasonably foreseeable, because one of the reasons why the tower collapsed because of the intervention with the flow of the water flow, okay, stream actually. Okay, and this is something which is reasonable, okay, but after some time, of course, it will cause the landslide, it will cause collapse of the building built on that slope, okay, on that area, hilly area. And then after all, okay, it was very strong argument here. It is also stated as part of the argument, it was recognized by existing engineering codes, okay. The moment somebody diverts, okay, the natural water flow, okay, so it is reasonable that a disaster will happen later. It will cause all those landslide or collapse of tower whatsoever. Second argument or second reason why respondent should be allowed to claim. Okay, the second argument, the drainage requirements for the hill slope imposed by JPS, Jabatan Paritan and Saliran, okay, the one who's in charge to monitor, okay, to supervise, were the result of its concern for the safety of the Highland Towers apartment blocks, okay, which were in close proximity. So now we look at the location, okay, how close it is, hill slope, okay, close proximity to the hill slope. So therefore, there was a direct link, okay, between the need for a safe drainage scheme and the hill slope, because it's hilly area. So it really needs this proper way of maintenance, okay, all the safe drainage, so that it will prevent from any disaster to happen later, but it happened already. And the third argument, the third reason, okay, why they should be allowed to claim for pure economic loss here. Highland Towers, now you focus on the tragedy itself, okay. Highland Towers tragedy incident, okay, rocked the nation and the world, because it rarely happens, okay. It doesn't happen every day. So 48 died, okay, in the incident, and many more were made homeless. And then the respondent is also trying to urge the court, okay, arguing that this court, okay, that public policy will only accord with common sense, that if MPAJ and its predecessor were held liable for requiring of approving. So meaning that here MPAJ should be liable, okay, for one of the parties responsible for the happening, for the tragedy, because they didn't do their work properly, okay, because they failed to ensure proper maintenance of the water flow, okay, in the hilly area. All right, so what's the decision after the respondent prove, okay, or produce all the argument here? So the court held that on the grounds to advance, the 3 grounds just now, okay, the 3 reasonings, yes, okay, the court agreed negligence would have been attributed to MPAJ, the local council, and or its predecessors. But okay, here halfway they succeeded already. The court accepted the argument, but okay, for the reasons already stated, actually they are MPAJ. Actually, they were immunized. Okay, they are given immunity, okay, against any liability under which act? Under section 95(2) of Act 133. So I reproduce the act here. So Act 133, is it 133? Yeah, Act 133 refers to Street Drainage and Building Act 1974, especially zoom to, we focus on subsection 2. Okay? It says here, state authority, local authority, and any public officer or employee of local authority shall not be subject to any action. Shall is a strong word, cannot be liable, okay, for any action, liabilities or demand, etc. Blah blah blah. By reason of the fact that such building, works, or the plans thereof are subject to inspection or approval, even though they are supposed to inspect or approve certain things here, but there is strong immunity. Otherwise, because they want them to discharge their duty, but then they don't want them to be, to be any problem from discharging their duty later if they were made to be liable, okay, for anything in respect of their authority or their work, okay, given your responsibility. So you can read the full section there. It's quite long. You can think how many sentences there, okay, how many lines, you can read later. But basically, this is strong immunity given by the Act, okay, by the legal provision. Okay, we stop here because I plan to divide our lecture into two parts. So this is the first part. So we're going to continue our lecture in the second part, covering the other two parts, okay? When recoverable and when not recoverable. So we stop here. Stop share. Assalamualaikum warahmatullahi wabarakatuh.